you know, each party will have 15 minutes to present oral argument, appellate first, and you have up to 5 minutes for rebuttal. You'll let me know if you wish to reserve any time. I'll keep it for you.
Your Honor, I would ask to reserve 5 minutes.
All right, very well. We read the briefs and we're ready to proceed.
May it please the court, opposing counsel Donald Gallick on behalf of defendant appellant Michael Hendon. Obviously, there are many assignments of error that have been proffered before the court. Unless there's any specific factual questions, I would go directly into assignment of error number 1, which I think sets the tone for the entire case. And that first assignment of error, as the court can see from the briefs, you have a prosecutor initially in using voir dire to violate the constitutional rights both of the Fifth Amendment and also the notion that both sides walk into the courtroom on equal footing. You have the prosecutor saying, do you think it's right that I can't call the defendant to the stand? Shouldn't we be able to call the defendant to the stand? Well, we can't because of the Constitution. And the prosecutor is the one that protects the Constitution. The prosecutor is the one that seeks justice. The prosecutor is the one who follows the law. In making these statements, it per se serves to disparage the other side. If I stand before this podium and say, Your Honor, I'm the counsel that does the legal research. I'm the counsel that is trying to follow the law. I'm the side that's trying to play by the rules and adhere to the Constitution. That's a per se ad hominem attack on opposing counsel. So when you go in and you say, I'm the prosecutor, we're the good guys here. We're the ones that make sure that all the rules and laws are followed. And that's why I can't call the defendant to the stand, and brings this up over and over again. The prosecutor is commenting on the ability or the inability to force the defendant to testify in the case. Case law is replete on that. The prosecutor is not in a position to raise that issue first. If the defendant raises the issue first, if defense counsel were to raise it, then certainly the prosecutor has the right to respond. But here you have in voir dire, prosecutor goes right up and sets the tone for the entire case and brings up the fact that she cannot force the defendant to the stand under the Fifth Amendment.
I'm not sure I saw in your brief direct quotes, perhaps I did, but it seemed to me that in the state's brief, they quoted the prosecutor as indicating that the defendant had the right not to testify, that this was a constitutional right, that it was not commenting on the silence, but rather indicating that this is a right and that the defendant did not have to testify.
There's certainly one angle that it could be looked at, but you sort of have to read between the lines here. I mean, if we have a robbery case and a person goes up and says, you know, you could give me your wallet because I can't kill you, you know, I don't have a right to shoot you in the head. It's like, gee, that's kind of intimidating, isn't it? You have the prosecutor who comes up and says, you know, I can't force him to the witness stand. He has those constitutional rights. I mean, it's unfortunate that he does. I mean, that's really the implication that we're giving to the jury. Why is the prosecutor saying what they're not allowed to do? You know, the prosecutor's going up there saying, I can't force him to the stand because, you know, he's got the constitutional rights. And we're the side that defends the Constitution. Well, no, everyone is officers of the court. At one point, the prosecutor says, I'm an officer of the court, and that's why I have to follow the Constitution. Now, the prosecutor's an officer of the court, the defense attorney's an officer of the court, the judge is an officer of the court. And both sides walk in there, they're supposed to be equal. So you walk in there and say, you know, gee, isn't it, you know, I have to prove beyond a reasonable doubt. Is that fair? There's 3 times that this comes up in voir dire. And at some point, defense counsel says, can we go to sidebar, Your Honor? Because defense counsel is worried of what the prosecutor is trying to do here, to paint the prosecutors as the good guys, and the judge overrules the objection.
And the sidebar, as I understand, the comments at sidebar were not reproduced and were not a part of the record on appeal.
There's some part in the transcript where the judge, or where the defense attorney tells the judge, I'm worried about where this is going, and I think the prosecutor says, well, you know, I'm finishing up or something like that. and the court says, I'm going to give a little leeway. I believe that's in the transcript. I can flip through the brief and maybe give the court a page number. I believe on page 262 and 263 there is some portion of that sidebar that's been transcribed. But what it will show is the trial court didn't seem to have a problem with the prosecutor going down this road and 3 times bringing up about the defendant's right to not testify. It seems that that's something that defense counsel has to initiate. Often in trial procedure, it depends on what's raised in your case in chief. You're not supposed to bring up a defendant's criminal history in their case in chief. Of course, it happens all the time, as we see in many appeals. But if the defense attorney raises the issue, well, then certainly the prosecutor has a right to respond and to rebut things that are brought up by the defense attorney. The Fifth Amendment right to remain silent is something that's owned by the defendant. It's something that defense counsel has the right to raise it first. It's not for the prosecutor to raise first and to keep telling the jury what, we have these constitutional rights that I have to protect, and that's why I can't force this guy to the stand.
Well, you're talking though about cases, and some of the cases that you cited had to do with matters that were brought up actually in the trial itself, the presentation of the evidence. This is voir dire, so should we look at this a little differently?
I don't know if the cases that I cite are directly on point, but I think from a conceptual standpoint, the concept is that it's not the prosecutor's decision whether or not this issue gets put in front of the jury. It's the defense attorney's ability to put the issue before the jury. If defense counsel says, I'm not going to mention the Fifth Amendment, we're not going to mention the possibility of the defendant testifying, I don't want the jury to even think about anything like that. That's their trial, that could be their trial strategy, that's their prerogative. That's been black letter law for a long, long time. If the prosecutor gets to decide the issue gets brought up in voir dire, the defendant has these constitutional rights and I can't take them away from him because I'm the good guys, I'm wearing the white hat here. That's a problem. And at some point, voir dire sets the tone for the entire trial. So once you have that coming right out of the gate, the jury's looking at the prosecutor as, that's the good lawyer, that's the one that follows the Constitution. Did you know the prosecutor is the one who's the officer of the court? You say, well, you don't see those words verbatim in the transcript, but that's certainly the tone and the flavor that's coming out in voir dire, and the prosecutor brings it up over and over and over again until the point where defense counsel says, is there some limit to what the prosecutor can bring up? Now that's assignment of error 1. Now I think assignment of error 2 connects to a lot of other assignments of error, and that is that there's no bill of particulars. One was demanded, and I know that the state brought up, it was held in abeyance, and defense counsel never pursued it. A request for a bill of particulars is asked for in April, and it's not discretionary. And I know there's case law from this court suggesting that it's really no big deal if they don't follow the statutory and criminal rule 7 mandates. It's shall furnish. It's not shall furnish, but don't worry if you don't do it. It's filed in April. In December, the trial court says, okay, the bill of particulars is held in abeyance. Never should have gotten to that point. You asked for a bill of particulars in April. Yes, Your Honor.
The court said it shall be held in abeyance.
Yes.
What was the circumstances around, how did that come up?
Yeah, I believe that came out right around, there was a pretrial or status conference, and I think there might have been some discussion that's not in the transcript, but they come out onto the record and they say, okay, like all sides agree that it's going to be held in abeyance or something like that.
So we don't know why.
I don't know if we do know, that's correct. But Your Honor, I think it's very important, the timing on this, that we're talking about 8 months after the bill of particular demand has been filed. And it is a shall issue. And courts are pretty clear what it means when the legislature puts shall in a statute, or we have a criminal rule that says shall furnish. Shall now doesn't necessarily mean shall. It's sort of, we've taken that word and we've put a little bit of gloss on it, and shall means, they can furnish one, but if they don't want to, we're not going to do anything to them. And why does that interrelate into assignment of error 2 and many other of the assignments? Because in the indictment, you have that Michael Hendon purposefully committed murder, multiple counts of murder. Then, in the middle of trial, you have the prosecutor says, well, he was there. Okay, well, he was there. Well, that's not purposely committing murder. Well, he stood there and watched. Okay, well, he held a gun. Okay, he held a gun. That's not purposely committing murder. Well, he was complicit. Okay, complicit doesn't appear in the indictment. There is no bill of particulars that was filed, even though one was demanded 8 months before it was held in abeyance. Was complicity ever put before the grand jury? We don't know. But in the middle of trial, now it becomes a complicity case. Is it complicity to purposely commit murder? The evidence that was adduced at trial doesn't seem to fit the facts. So we switch the facts to complicity, and so you have a trial going on where neither the defendant nor defense counsel really knew what the case was about until the middle of the trial. In openings,
Excuse me.
Yes, Your Honor.
You're at your 5 minutes. If you want to continue, you may.
Your Honor, I'll just say this, that when the opening statement occurred, the prosecutor said Michael Hendon purposely committed murder. That's what they set out to prove. Then it's like, okay, well, he was there, he had a gun, he was complicit. So you look at the opening statement and the closing argument, they're very different facts that the prosecutor alleges. I'll reserve the balance of my time.
May it please the court, counsel, Heaven DiMartino, on behalf of the state of Ohio, we are asking that this court affirm Michael Hendon's multiple convictions for violent felonies, including the aggravated murder of John Kohler, David Carpenter Kohler, Ashley Carpenter, and the attempted murder of Rhonda Blankenship, who was present in the home when her boyfriend and her 2 stepchildren were murdered by 2 brothers, Michael and Eric Hendon. With regard to the first assignment of error, the state would point out that this discussion was during voir dire while the prosecutor was attempting to explain to the jury the process of a jury trial. So it's very clear when you take it in context. The prosecutor was taking the time to help the jury understand, here's what the process is. The defendant has a constitutional right not to take the stand, and not only that, they don't have to do anything. Do you understand? That's a correct statement of the law. It's the prosecutor explaining to the jury what's going to happen to ascertain whether there's any bias or belief in any of the potential jurors that perhaps the state has an obligation to call the defense. Maybe the jurors believe that the state has an obligation, if they think the person is guilty, that they have to call them to the stand. That is a legitimate issue to determine during voir dire. The other statement the prosecutor made with regard to the right not to testify was, do you understand the defendant has a right not to testify, and the state cannot and will not call the defendant to the stand? Those are 2 comments. They do not in any way, shape, or form insinuate, allege that the prosecutor is making a statement on the defendant's failure to testify. We're not even at a part of the trial where the defendant would have had the opportunity to testify. These are not over and over and over and over as defense counsel attempts to characterize the voir dire before this court. It was 2 occasions. The third statement that the prosecutor made was the idea that the prosecutor has the duty to uphold the defendant's constitutional rights and not win by any means necessary. So that was just a comment regarding the fact that as prosecutors, we have to follow the rules. It's the state's job and the defendant's job and the judge's job to make sure that the defendant gets a fair trial. And that, again, is a correct, accurate statement of the law, of the obligation of both sides as well as the court. It is not in any way, shape, or form designed to put the prosecutor in a position of attempting to persuade prospective jurors that we are the people in the side of justice, that we are the ones who do the research, or we are the ones who do anything differently than the defense. It's just a complete mischaracterization of the voir dire, and the comments in the brief that relate to other cases where this particular prosecutor or another prosecutor may have done something that this court characterized as improper but did not find rose to the level of misconduct is disingenuous, in my opinion, as a way to attempt to convince this court that this prosecutor in a triple homicide and a 4th victim who was in the house and heard her stepchildren and her boyfriend get murdered by these 2 brothers is a mischaracterization of the voir dire. And it is something that the state would opine is not reversible error and was consistent with the law.
Well, counsel points out that the prosecutor appeared to put the state on a different level by saying that it is the prosecutor that is the champion of the rights of the defendant, and did not include the defense counsel as an officer of the court, or the court itself.
Well, this is a statement that's taken out of context. There was no attempt to make it look like the state was the only person that had a duty to uphold the defendant's right. The prosecutor was going through what the defendant's rights were and explaining why the state was going to present its case in a certain way. That there's constitutional rights of the defendant, and that we, as the state, are going to respect those rights. And therefore, we're not gonna call the defense to the stand, and wants to make sure that every potential juror understands that. Because not every potential juror has ever been in a courtroom. Maybe their only exposure is, things on TV. But when you read the entire voir dire and don't pull out these three statements, which I completely disagree, even taken out of context, create the inference that counsel is attempting to create. If you read it in the context of the voir dire, it's very clear that this particular prosecutor was going through very carefully to make sure that we were obtaining a jury that was going to be fair and impartial, so that Michael Hendon would get a fair trial, and that we would be able to obtain justice for the 4 victims in this case. With regard to the bill of particulars, the record shows that there was a pre-trial hearing where the court went over a number of motions, and there was a discussion about whether or not the motion for a bill of particulars was moot, and defense counsel advised the court that basically we'd like to discuss it at a later time. The court indicated that she would overrule that motion for a bill of particulars. At that time, defense counsel said that he would find another way to get the issue before the court, and therefore I will hold this in abeyance. And the court said, at your request, I will hold this in abeyance, pursuant to the defendant's request. So he has waived, forfeited any ability to raise this issue of a bill of particulars. Counsel is correct that the current standing of the issue of bill of particulars in the 9th District is that it's generally not reversible error. The bill of particulars is not given. And in this case, you have that case law plus the fact that it was the defendant's request to hold it in abeyance. There's no way that the court can be found to have committed error when it was the defendant's request to hold it in abeyance on December 23rd, 2014, and the transcript of that proceeding is included in the record. The crux of the balance of appellant's arguments with regard to sufficiency and weight are built on this improper foundation that the state committed error by somehow creating a biased jury that believed that the state was the only person looking for justice, and that everything the state did should be believed over defense counsel, which is basically just reiterating his first assignment of error. And then the other underlying theme is his issue with complicity. And the Supreme Court of Ohio in hearing said that you don't have to charge complicity. It's basically inherent in every indictment. The complicity statute 292303F says the same thing. You can charge someone in terms of the principle without mentioning complicity, still give a jury instruction on complicity, and the person can still be found guilty of complicity. The 9th District has defined what aiding and assisting is, which is what the jury instruction was given by the court, which was that Michael aided and assisted his brother Eric in committing these crimes. It doesn't really matter whether we ever know if Michael Hendon actually pulled the trigger. We know that there were 3 people dead, 1 person seriously injured. We know that Michael and Eric were both in the room when the children were killed. We know that there were 2 guns. We know that there were 2 different bullets that were found. There's absolutely nothing in this transcript to support the contention that Michael was just some quiet, passive observer. When these 2 brothers entered that house, the first thing that Ms. Blankenship testifies to is that Michael Hendon put a gun to her head and shushed her so she didn't speak. So this is not a situation where there's any plausible argument that Eric was the only person involved and Michael was just quietly along for the ride and was trying to stop what was going on. He was in the room when all 3 people were killed. He was in the room when Eric stabbed and shot Rhonda Blankenship, and he also had a gun, and he also used it to help commit these crimes. If there are no questions, I would rest on my brief.
Thank you.
Thank you, Your Honor.
Val, you have about 4.5 minutes.
I want to note something that the state said during oral argument, saying that there was, during the discussion about the bill of particulars, the trial court said it's going to be overruled, and then defense counsel says, well, can we at least hold it in abeyance and get to the issue another way? So, to say that the issue is waived, defense counsel asked for it in April, and then in December still doesn't get it. The trial court says, well, I'm inclined to overrule it. Well, at a minimum, Judge, can we just hold it in abeyance so we can get to it later? You shouldn't even be having this conversation in December because, again, it's statutorily mandated, and it's mandated under Criminal Rule 7E.
Is there a time frame during which the court is required to act under the rules?
Your Honor, I don't think there's case law on that because I don't think there were problems with courts denying bill of particulars until the past 10 years. I think this problem is not just in this district. I've cited case law in other parts of Ohio where there's some controversy on this. But this comes out of the due process clause, saying, well, we'll give you a bill of particulars the day before trial. Well, what good does that do anyone? You need to have the bill of particulars well before trial, but I don't think there's a bright line deadline. It must be given 30 days before trial. Certainly what we have now is generally it's not given at all, even if you wait 8 months. There are witnesses in the transcript that said Eric did all the shooting. I know the state said there's no reason to believe from the transcript that Michael wasn't part and parcel of this. There's prosecution witnesses who say Eric was the one that was doing all this. Michael kind of stood back and was quiet. That's on page 1202, 1202. Another witness, Michaela Barrett, said Eric did all the shooting and Michael didn't want people to get shot. That's on page 531. When you go through the transcript, there's substantial testimony saying that Michael wasn't really part of this, other than him. I mean, obviously you say, well, he shouldn't have been there. He shouldn't have accompanied his brother. He should have had nothing to do with this. You're certainly right about that. But the transcript suggests that Michael was not purposefully engaged in the act of murder in this case. And even the judge at sentencing seems to say, well, I know you didn't go in there to hurt anyone. I mean, the judge says this at sentencing. Obviously, the judge saw the whole trial, and the judge said, even though
that's not, if you look at the test for complicity, the fact that he did not go in there to hurt anyone or did not pull the trigger doesn't really resolve the complicity issue.
That's exactly right. But it does go to the mens rea of purposefully. And so this is one of the problems. We see we don't follow this law, and that creates a problem for not following this law, and it creates a domino effect. We don't have a bill of particulars. We don't know the theory of the case. It turns into complicity in the middle of the trial. And correctly, there's case law saying, well, the state can do that because what the state says, complicity is sort of inherently built into all these other things. But then you have, most likely the grand jury told he was purposely engaged in murder. Opening statement, you tell the petit jury he's openly, purposely engaged in the act of murder. And then, oh wait, he was complicit. Was he complicit in being purposeful to achieve the unlawful taking of a life? So this gets really interesting, how complicity affects the mens rea of the substantive crime. We wouldn't have this problem if there was a bill of particulars filed, or that we had something in the indictment, a two-wit in the indictment, saying on such and such date, Michael Hendon went in and planned the murder, or went in and told his brother to shoot this person, or something, some specific act, the actus reus, to merge with mens rea. If we want to go back to first year law school on this, fairly theoretical information. Instead, we're here saying, well, we don't really know what the theory is, we don't really know what the allegations are, but he was there, he had a gun, he was with his brother, he's probably guilty of purposely committing murder. At a minimum, he was complicit. There's real due process problems here, and that's why some of the assignments of error are interrelated, because you have one constitutional deprivation which leads to another, disregarding statutory and criminal rule mandates. Certainly are there some things that Michael would have been convicted of no matter what, no doubt about it, but to say that he was complicit in purposely committing murder by being there, having a gun, and accompanying his brother to the scene, it doesn't seem like proof beyond a reasonable doubt. If there's no further questions, I thank the court for its time.